Welcome to the Virtual Center for the Study of the Constitution and Civic Responsibility, an ongoing inquiry into American political origins and evolving institutions. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He's also your host for this continuing conversation. Here he is now, Dr. Bill O'Brien.
Thank you, Bob Kincaid, and welcome to the Virtual Center for the Study of the Constitution and Civic Responsibility. It is Monday. It is the 11th day of January in the year 2016. I'm saying that advisedly because I mean, obviously, as everybody else am still inclined to say 15 unless I force myself and remind myself. So I'm trying to get into that habit, as it were. Welcome to a new week here at the Virtual Center. It is an absolutely gorgeous day here in Appalachia, but winter has arrived. It's very, very cold. We were in the single digits this morning, and we're looking at probably some snow flurries during the day tomorrow with a potential for a couple of inches of accumulation. So I guess our extended fall period or season has ended, at least for the time being, although now we're starting to get some reports from weather folks that maybe this winter is not going to be nearly as bad as it was projected to be before it began. Welcome to our program. Welcome to a new week here at the Virtual Center. I want to thank you for your continued support and you're continually tuning into the Virtual Center. I also want to thank you, as I try to mention, for your continued support for the Head On Radio Network as well. As you know, this program would not be possible were Head On not there. So I think every effort that you can make in support of the Head On Radio Network and nature in light of the kind of programming that network carries, I think is very, very important. So I want to thank you for your support of the Head On Radio Network, and more specifically, from my perspective, I want to thank you for your continued support for the Virtual Center. I also want to encourage you to participate in our program even more actively than listening, for which, as I say, I do genuinely appreciate you for that. But I also want you to know that we have a number of ways that you can participate even more actively by getting your ideas and your thoughts before other people. One way is to use our phone line, which is dedicated just for the purpose of you being able to get on the air. Another way is to go through me, contact me directly, and I'll do the very best to get it on the air for you if that's your preference. Our phone number is area code 304-663-4676. 304-663-4676. And again, 4676 translates into Horn, H-O-R-N. If you would prefer to share your ideas or thoughts with me directly, one-on-one, you can do that via an email. My email address is waobrien906@gmail.com. That's waobrien, O-B-R-I-E-N, 906@gmail.com. And again, I do remind you that we have a Facebook page dedicated to the Virtual Center. And if you do go to Facebook, if you are a regular user of Facebook, and you go to the homepage of Facebook, in the search box at the top, just type in the Virtual Center for the Study of the Constitution, and you will indeed have access to our Facebook page. There are a number of postings on there. I've been a little bit better of late, I think, in utilizing it. It was interesting because when I was traveling over the holidays, I got a note from Facebook that it had been several days without a new posting on the Virtual Center website. And so even Facebook itself is not going to let me go too long without putting something on it without a reminder. But I've been doing better, I really think. And a lot of times it's I've taken to reacting to issues of the day that seem to me worthy of of reaction, especially if they pertain closely or directly to issues that we've been covering here at the Virtual Center. And so basically, I do encourage you to check the Facebook page and feel free to comment on any of the postings there. I take responsibility for them. I try to maintain the page as best I can by updating and putting additional materials on it. So over the last few weeks, there's been a number of postings, and I indeed posted a couple of times over the weekend. But as you'll hear in a moment, I spent the bulk of my time this weekend working on the issue of gun regulation, and you'll recall that was really the focus of our last program together last Wednesday. So I kind of want to open our program today by sharing with you where that particular issue has taken me over the weekend. I put together a piece that I submitted to a couple of friends, and I just this morning submitted it for publication in the West Virginia statewide newspaper, the Charleston Gazette. And I'm hoping, I trust that at some point in time they may choose to publish this particular piece. I hope so. But in the interim, and portions of it, rough drafts of it, are on the Facebook page as well. So what I'd like to do today in our program is open our program by sharing this with you. Then I'd like to pursue the issue of gun regulation even more, because this particular issue led me naturally, as I think it should, to the Supreme Court decision relating to guns, most specifically the very well-known Heller decision, District of Columbia versus Heller, which was the case that was heard before the Supreme Court in 2007. And I spent a good portion of the weekend reading the decisions and the dissenting opinions in that case, and I want to share some of my thoughts and indeed some of the highlights, it seems to me, of those opinions, both the majority and the minority or dissenting opinions, with you, because I think they are quite relevant. They're quite relevant to the issue of the day. And of course, these are the issues that we've been dealing with, but of course they are very timely right now, because President Obama, in his last year as president, has taken or is in the process of taking executive office initiatives on the issue of gun regulation and registration and background checks and those kinds of things. And you know, we commented on a little bit of that last week, and I kind of want to get back to it. But the point is, the president, as a result of this last situation in San Bernardino, has taken it upon himself after, and I see various numbers as to mass shootings that have occurred during the Obama administration. And I saw one number that totaled 33. I saw another number that totaled 27. I think the president himself, in one of the comments that he made, I saw in one of the news broadcasts, made reference to 30 or in excess of 30. The fact of the matter is, in 7 years, mass shootings have become an issue, and obviously the president has kind of thrown up his hands in frustration over not being able to get anywhere with Congress, and has decided to do what he can do on his own. And he's been having conferences with members of his administration, especially his Justice Department, his Attorney General, and other people on actions that he believed would be within his constitutional prerogative as president. And of course, he's getting a lot of blowback from that, as one would understand. The Republican candidates are to a person, are promising that anything that he does by executive action, they will undo should they be elected as a first order of business once they take office next January. So again, how effective in the long term these issues are going to be, it seems to me are still a little bit up in the air. The piece that I've written, and the one that I wanted to open today's program by sharing with you, is focuses on the Atlantic magazine article by Saul Cornell, the historian at Fordham, used to be at Ohio State University. This is the one that we focused quite a bit on Saul Cornell's article last week. And as I've mentioned, many of the things that I do write and I do post on Facebook oftentimes stem from programs that we've done here at the Virtual Center. Well, these things are kind of, at the forefront. They're kind of right on the tip of my tongue, so to speak, if we've just done a program on them. I'm inclined to, especially if I think that they are issues, and of course, the mere fact that they're on here, I do believe that they are issues that are quite consistent with the mission of the Virtual Center. But I don't like to lose them, because I know that once you get 4 or 5 days beyond the program, there is an inclination for the details to kind of slip off into the distance, fall through the cracks, so to speak. It's much more difficult then to sit down and recreate a program once it's been over for an extended period of time. So I'll usually basically try to make the move as quick as I can. And that's what I did this weekend, on this past weekend and the few days before, Thursday and Friday of last week, when we don't do a program here at the Virtual Center. The title, and of course there's a number of different titles that one could have, but the one that I chose is entitled "The Historical Record." The Historical Record Revisited on Regulation of Firearms. I just realized there's the three words in that title beginning with the letter R. So it's become a little bit of a tongue twister, but I didn't realize it until just now. The Historical Record Revisited on Regulation of Firearms is what I've entitled this. Let me tell you where the initiative to write this came from. I had just done our last program on Wednesday, and we spent quite a bit of the program focusing Tuesday and Wednesday on Saul Cornell's research. You'll remember Wednesday that we had, I believe we had a couple of callers, and so most of our program Wednesday was interacting with listeners, which is wonderful. I think we had 2 different callers on that day, as I recall. So much of what I referred to as happening last Wednesday actually probably was Tuesday of last week. We spent most of our time with Saul Cornell's research. But this weekend, to be honest with you, to be specific, Friday morning, I was looking at an editorial in the Richmond Times-Dispatch in Richmond, Virginia. Occasionally I do that. I lived in Richmond for 19 years before I came to West Virginia in 1991. So I lived in Richmond from 1975 until 1991. And so I still have interests there. I still, kind of follow the athletic teams a little bit. I keep up with Virginia Commonwealth University because not only did I teach there and actually was in administration there for 3 years, but also because I believe it's one of the finest universities that we have. One of the things I used to tell people when I was there all the time is that Virginia Commonwealth University I believe is one of the best kept secrets in higher education. It's very popular in Virginia, in the Richmond area, obviously. The fact of the matter is, it's one of the finest institutions I've ever been affiliated with. I know their School of the Arts, especially the performing arts, is second to none. And it is just a great institution. But anyway, my point is that every once in a while, I'm inclined to go online and look at the Richmond Times-Dispatch just to try to get a feel for the kinds of things that are going on in Virginia generally, but most specifically in the Richmond area. But this particular day, Friday, I had an extra added reason for going there. And that is that a good friend, a former colleague that I taught with in Richmond, Virginia, I taught history, he taught political science, sent me an email and mentioned to me that he had been frustrated all day long because of an editorial on President Obama's issue on gun control, that the Richmond Times-Dispatch had written an editorial which really got under his collar a little bit, and he sent me a copy of it. He attached a copy of it to his email. And so I looked at it, and because I read many of the things he said about it, I looked at it. Then I went to the Times-Dispatch and read it in the paper itself to make sure that, that what I was reading was accurate, and indeed it was. And obviously it was quite critical of President Obama. It was quite critical of the regulation of guns. It was quite supportive of the idea that the Second Amendment, and specifically the Heller decision, had pretty much affirmed for the nation once and for all that people's ability to own and carry firearms in their own defense as well as in the defense of the nation was a constitutional right, and indeed was a human right in this country even before the Constitution. Which again kind of got my attention as well. The very last sentence in that editorial it's well written, but it's probably more than anything else the line in the editorial that got to me, and it prompted me to write the piece. I opened this particular article with a citation, with a quotation from the Richmond Times-Dispatch of that last sentence. Let me read it to you. It's obviously referring to President Obama. Quote, "Nevertheless, he is determined to leave office as he entered it, bent on restricting the rights he doesn't like of the people he doesn't understand." That particular line, that particular sentence, I chewed on for a while, and it, more than anything else, prompted me to put together many of the things that we've been talking about here at the Virtual Center, in addition to some of the things that I've been hearing discussed on talk shows and panels and those kinds of things. So let me share with you the first couple of paragraphs here, which relate specifically to that. This closing from the paper's editorial on Friday, January 8th, speaks volumes about why we can't seem to get out of our own way in our search for consensus on some of the nation's hottest, most contentious issues. The issue at play here, of course, is guns. The tone which pervades the entire Richmond Times-Dispatch piece suggests that the real source of the disconnect here is President Obama's unwillingness even to try to understand what motivates those with whom he disagrees. By far the most devastating aspect of this criticism is the suggestion that the president will leave office a year from now without having made the slightest attempt to understand his adversaries or inform prejudices he brought with him to Washington 7 years ago. The implication, of course, is that whatever adjustment was required was the president's to make. Nowhere is there even the slightest suggestion that the people he doesn't understand, in quotes, might possibly be wrong. Instead, the editorial assigns to Mr. Obama the liability for what it calls an obsession about guns that has informed his entire 7 years in office. Never mentioned anywhere is the seemingly endless parade of mass shootings, and in parentheses, I put more than 30 because that's what I heard the president say, that has so dominated his years in office. And there's nary a mention of the scores of distraught families President Obama has cried and grieved with during these many episodes. Even without an obsession at the outset, most humans would surely leave with one. So my suggestion there is focusing on the allegation that the president came into office obsessed with the issue of guns. And what I'm trying to suggest here is if he didn't have an obsession about guns when he came, after more than 30 mass shootings, he sure would have one when he was leaving. Instead, the reader is asked to buy into the idea that Obama came into office on a mission to restrict gun ownership in America and will leave having failed to achieve that principal objective. What he's refused to recognize, this scenario alleges, is that those he considers his key adversaries have been waiting in vain for the first sign from the White House that their views are considered legitimate and worthy of serious consideration and sympathy. Oh, the rhetorical appeal of victimization. How best to respond? Think Affordable Care Act. Think Mitch McConnell. Speaking of mission, track McConnell's professed commitment over the years to derail every single initiative that comes from the Obama White House. Methinks the Times-Dispatch does protest too much. In the Atlantic, and this gets into Saul Cornell's research, in the Atlantic magazine, December 17th, 2015, Fordham University historian Saul Cornell introduces research to indicate that Obama's critics on guns are not only wrong, but duplicitous in their assertion of founder intent on the individual's right to own and carry, and unwillingness to consider evidence that might just force them to compromise their position. But on this most agonizing of issues, things just might be about to turn around. Entitled Guns Have Always Been Regulated, Cornell points to the number of American colonies prior to 1776 and the number of states after it that regularly passed legislation on gun ownership in order to ensure that citizens required to serve in the state militia showed up ready to fight. Even after the Second Amendment was ratified in 1791 as part of America's Bill of Rights, Cornell reports, most states reaffirmed their right to insist that prospective militia recruits own the kinds of weapons they would need in case of an emergency call-up. Even when their property was seized for back taxes or debts, their muskets were exempt, while the weapons they used to hunt were subject to seizure. In other words, the issue there is that many states, by law, exempted military hardware, the guns that they needed to serve in the military, from confiscation, even though the guns they use for hunting, along with their other property, might be confiscated for back taxes or non-payment of debts. I think that's an incredible piece of historical information. Several slave states were able to overturn these regulatory laws, Cornell recognizes, but most states upheld their legitimacy, even in the context of the recently ratified Second Amendment. Justice Scalia, Cornell points out, naturally focused on the state laws rescinded, but neglected entirely those that were not. And of course, what he's referring to is Justice Scalia's opinion in the Heller decision, which is what led me to spend the weekend reading that. I'll get to that later in our program. The Heller decision, Scalia's majority opinion, as well as Justice Stevens's dissent, validate Cornell. Both sides disagreed on the exact meaning of the state-based legislation both cited. But the very fact that these laws exist at all is Cornell's point. Governments regularly addressed gun legislation, both before the Second Amendment and after it. To deny the legitimacy now of what was acceptable legislative practice then is at best heretical. To do so knowingly by falsifying the historical record violates judicial ethics. The message Cornell sends is crystal clear. First, despite efforts by the NRA, gun manufacturers, spokesmen for the nation's right wing, and their conservative minions on the Supreme Court, specifically Justices Scalia and Clarence Thomas, to challenge regulation of guns as a violation of the Second Amendment and contrary to what the founders intended when they affirmed the right to bear arms, the historical record tells us just the opposite. In other words, despite all the evidence, all the protestations by the NRA, by gun manufacturers, by gun supporters, by conservative and right-wing Republicans, spokesmen, by conservatives on the Supreme Court, despite the number of times and places they have asserted that regulation of guns violates the Second Amendment and is contrary to what the founders intended when they affirmed the right to bear arms, the historical record tells us just the opposite. Second, governments in this nation regulated guns regularly. The successful challenges of slave states were not the rule, as Justice Scalia alleges in District of Columbia versus Heller, but rather the exception. In most states, laws regulating gun ownership were common practice and went unchallenged. Third, the idea of a well-regulated militia, so often denied by gun advocates when they argue for the right to bear arms, was indeed the founders' principal consideration. Justice Scalia went to great lengths in Heller to separate the right to bear arms from its military context, establish it as a standalone phrase, and deny, often with tortured logic, rhetoric in state constitutions that seem to refute the conclusion he intended to make. He challenged Justice Stevens and the liberal minority with his usual resort to sarcasm, terming their efforts to alter the founders' meaning of text with qualifiers as, quote, worthy of the Mad Hatter, unquote. Saul Cornell's research suggests quite the opposite, that without the well-regulated militia qualifier, the right to bear arms made little sense. And fourth, on this issue, gun regulation, the conservative majority on the court has regularly violated its traditional stand against judicial activism. Fact is, where guns are concerned, these justices have regularly practiced it. Saul Cornell is telling us that we've been duped on this issue for too long. It appears now that the president has taken the first steps to right a serious wrong. To those innocents who've been slaughtered over the years because those we've elected were too intimidated to stand up to the gun lobby, it finally appears that the will of the majority will rule the day. That's pretty much the sentiments that I had on this particular issue. It's pretty much of a summation as well. It serves as a review of our last couple of programs here at the Virtual Center. And for those of you who were with us on Wednesday when we did get our callers, you may recall that the callers themselves were focusing on much the same, this very same issue of guns. So in a sense, with the situation that continues to go on in Oregon, with the seizure of the federal wildlife facility there, it seems to me these kinds of issues are quite timely. They are right on everybody's lips right now. Most of the media is focusing on one or the other aspect of these things. It seemed to me, and I guess maybe we could be criticized for not doing this earlier, but it seemed to me, going back to Heller, which really, since its 2007 airing, the decision was reached, has pretty much been touted as the final word on guns. Many of us know, we've talked here and other places as well. You've heard about various moves to amend the Constitution. We just talked about that when we talked about Mark Levin's Liberty Amendments and some of the efforts of ALEC and some of these conservative groups to initiate an Article 5 convention, which would make it possible to consider various amendments to the Constitution of the United States. But the amendment that really, more than anything else, is driving that move is the Balanced Budget Amendment. But as we know, many liberals have also begun to advocate a constitutional amendment to try to overturn the Supreme Court's decision in Citizens United in order to take the obscene amounts of money that are pouring into our political campaigns, in order to take these huge contributions off the table and try to return to some semblance of sanity in our election campaigns. And of course, many people look to the issue, which has been around for a number of years, of course, the idea of public funding, and going back to the idea of public funding of our election campaigns, of reducing the length of time that it just seems like our election campaigns never end. We just go from one to the other, and a number of other things. One of the things that occurred to me this weekend as I was mulling over and doing some writing on this stuff was that maybe down the road we may be able to look for a reversal on Heller. But, the more I think about it, I think that's a long way coming. But on the other hand, it makes pretty clear how significant the fall election will be, because the anticipation is that whoever's elected president in 2016 is probably going to promote 3 different justices to the Supreme Court. In other words, the makeup of the Supreme Court for Lord knows how long into the future is going to be on the table when we cast that ballot this fall. And given the number of issues and decisions that have been reached, Citizens United, the Article 5 convention idea, Heller, many of the other things that people don't like about what the Supreme Court has been doing of late, especially under Justice Roberts, tutelage, should be very, very interested in appointees to the Supreme Court. So there's absolutely no question that an awful lot of those appointments is going to be determined by who wins the White House in this fall election. I think everybody recognizes this, but I think it's a good thing every once in a while to remind ourselves of it and say it. Anyway, what I did was I went back to Heller and I read the decision. Let me tell you a little bit about it, for those of you who haven't read it. First of all, it's a lengthy opinion, as I usually do, because if I'm going to take time here at the Virtual Center on a particular piece of text, then I like to print it out. I like to have a hard copy so that I can share with you, because in dealing with documents, and for example, I think what we've done over the years, over the months and years, with the Federalist Papers has pretty well necessitated that I have a hard copy of the document, because we're talking about text. We're talking about language. We're talking about the way a particular issue is discussed, is written up. And so in order to do that, it seems to me, you've got to be dealing with the text itself. The whole idea of primary documents, of primary source materials, is one that I've been pushing and pushing and pushing. And I have tried to conduct the programs here at the Virtual Center with that message in mind. And so as much as I possibly can, I've been trying to deal with source material, with accurate source material, rather than just commenting on things and generalizing, perhaps overgeneralizing on some of these critical issues. So what I did is I went back and I printed out Heller. And it's the opinion written by Justice Scalia, prints to 27 pages. Then I looked at the dissenting opinion written by Justice John Paul Stevens. As I'm sure you know or can imagine, the Heller decision was one of those 5-4 decisions. The dissenting opinion, or the minority opinion, was written by Justice Stevens. It prints out to 17 pages. So that's about 44, 45 pages of text on Heller. And then I went through and I basically highlighted or marked up certain what I think are key areas in the decision, whether it be the opinion of the majority or whether it be the opinion of the minority, in order to try to get a handle and be able to draw some what I think are sustainable conclusions about the Heller decision. So with that, and before we actually go to the text, let me, if I can, make just a few general observations or comments that I've reached upon reading this. And again, this is kind of old stuff, because it was the case was heard in 2007. I think it was entered into the register, into the Supreme Court log, if you will, and published in 08, early in 08. But the case was heard in 07. A couple of general conclusions about it. One of the conclusions I have reached after reading both the opinion, the majority opinion, and the dissenting opinion written by Justice Stevens, one of the conclusions I reached was that the Heller decision, in my view at least, is a classic example of judicial activism. It is, I think without doubt, a decision that Justice Scalia wanted to make going in. It is not a decision based on the evidence. The evidence seems to be based on the decision that the majority wanted to reach, which was that the right to keep and bear arms is an individual right, not a right reserved only to those serving in a militia or a military branch of military of some sort. That's the first thing, the issue of judicial activism. And of course, the reason I say that is because traditionally it's conservatives who have been most adamant against liberal efforts on the Supreme Court to engage in judicial activism. And what I'm talking about here is making law, rather than interpreting the law in order to determine exactly what the law is, what's constitutional and what's not. The court has been accused many times by both sides of engaging in writing legislation, of actually passing law. And the fact of the matter is, if you look back on it, you can see it. The classic example, and the one that conservatives point to all the time, is the school integration decision, Brown versus Board of Education in 1954. It's clear that the context within which the Brown decision was reached in 1954 to integrate schools, it's clear that the context of that decision seemed almost to call for the particular decision that was reached. The situation that the nation was in the early 50s seemed to mandate the barring of segregated education as unconstitutional. Many cases were leading up, cases led up to the Brown decision. And conservatives spent an awful lot of time after that decision arguing that it clearly was a decision that the liberal majority on the court wanted to reach. And if you look at the historical evidence surrounding the decision, there's no question that they are correct. That indeed this was a decision that had to be made. The nation had to go in this direction for a number of reasons. The issues of justice being one of them, but not the only one. The Cold War at the time. Many foreign policy experts appeared before the court and testified that the United States of America was in a struggle for its very existence against the threat and the spread of international communism. And that whether we won the Cold War or lost the Cold War would be decided not here within America, but throughout the underdeveloped world. And the point being, most of that underdeveloped world is non-white. And these people argued that it is totally hypocritical for the United States to try to conduct foreign policy and win allies in the non-white world when we continue to practice segregation and racial privilege here within the United States itself. We end up talking out of both sides of our mouth. The argument was made. So the point is that there were a lot of reasons: quality of education, justice, fairness, the threats of a segregated society, the social threat of a segregated society, international affairs. There were so many situations and so many things calling for that particular decision that there's absolutely no question that the court was almost bound to reach the decision it reached. In fact, if you read the majority opinion, the court rejects almost upfront, right away, historical precedent. Because the court points out that most historical precedent validates segregation, validates racism. So what we're talking about here is the need to go in a different direction. And if we're going to go in a different direction, then you pretty much have to ignore precedent. And so what the court does instead is rely on testimony of psychologists and sociologists who are basically arguing about the psychological damage being done to minority children in segregated schools. And study after study is presented to the court, which reveals or reflects the psychological damage, lifelong damage that is done to children who have experienced this kind of institutional racism as it was being practiced in our schools. So the court itself acknowledges that it's doing something that elected politicians could not or would not do, which is take the nation in a new direction. At the time, when I was in graduate school, I can remember doing research on papers. And my argument was that really there's a whole history of evidence to suggest that throughout our history, the Supreme Court has taken the lead in leading the direction in the nation in a different direction when it was politically uncomfortable for elected representatives to do it. In other words, if a particular issue was so explosive that politicians who were seeking to be reelected were afraid to touch it, then the only way for the nation to go in those directions is to not rely on Congress, but rather rely on the court. Since the justices didn't have to be reappointed, they didn't have to run for reelection. As Hamilton said in Federalist number 78, lifetime appointment makes it possible for the justices of the court to give decisions that are not, make decisions that are not popular. And one of the things that I saw found in my research was that this has happened in a number of situations throughout our history. And actually, the particular piece of legislation that I was researching at the time was the 1914 decision which legitimized or legalized labor unions in this country, the Sherman. It was the Sherman Act, I believe, not the Sherman Antitrust Act, but the 1914 legislation which legitimized the right of organized labor to bargain, to the right to organize and the right to collective bargain. That ultimately this was a decision that the Supreme Court made because there was no way to get it through the Supreme Court. And the nation was experiencing all sorts of labor and civil strife in the country. And the only way to address it was to do something that Congress was unwilling to do. Consequently, the court did it. So again, I think there's tradition here. Over the last half century or longer, since the New Deal, it's pretty much been conservatives who have challenged the activism of the Supreme Court, the behavior of the Supreme Court in taking the nation in directions that really, legally, constitutionally, the argument goes the court had no right to do, because the court's job under the Constitution is to interpret the law, not make it, let alone administer it. And if you remember a couple of months ago, when we were looking at the criticisms of the so-called administrative state, that's one of the major criticisms of the federal agencies that have grown up under the executive branch of government, that because of the reliance of these particular agencies on the expertise of the people who staff them, then more often than not, these agencies become legislative, executive, and judicial all at the same time. They not only operate without being accountable to Congress, as well as accountable to the president because of the expertise they have, but in many cases, they also operate in a judicial framework, because many times they're the ones who make the decisions as to what areas they should go into or have the right to go into, or what areas they should not. These are judicial decisions that these agencies make as well. So we're talking about a principle here that it's very well established. But traditionally, over the last half century or more, it's been conservatives who have charged judicial activism on the part of liberals. And I guess I'm the product of that. So consequently, when I see examples of judicial activism being undertaken by conservatives, I react to it, because it seems to speak a little bit to a bit of hypocrisy. It's, to argue against judicial activism and to make the case and support the constitutional philosophy of judicial restraint, and then at the same time practice judicial activism when it suits you, seems to me to be, in many ways, the height of hypocrisy. I think we see it. We see it in a number of places. I see it in the Heller decision. So that's the first thing. And what that means is, if indeed judicial activism is valid, then what makes it valid is the fact that the court, in its opinion, handles data, handles arguments in such a way that it's manipulating the situation in order to support a decision that it has already made the decision to reach. In other words, instead of the data producing the decision, it's the decision that drives the data in a situation of judicial activism. And as I read the Heller opinion written by Justice Scalia, that's what I see. Let me share with you just a little bit. I know we're getting towards the top of the hour, but we've got about 5 minutes before we pause to take our break. So let me share with you just a couple of things. For one thing, let me share with you what the Heller case was about. This is from the opinion written by Justice Scalia. And the issue, of course, is whether, in fact, the District of Columbia is within the Constitution when it passed regulations against the ownership of handguns in one's home, whether, in fact, that violates the Second Amendment to the Constitution. Here's the background to the case as explained by Justice Scalia. The District of Columbia generally prohibits the possession of handguns. It is a crime to carry an unregistered firearm in the district in Washington, D.C., and the regulation of handguns there is prohibited. So that effectively eliminates handguns if you have a handgun, it has to be registered. And if you can't register them, then obviously you can't have them. Unless of course you are violating the law. But there's more. Wholly apart from that prohibition, no person may carry a handgun without a license. The chief of police may issue such licenses for 1-year periods only. Excuse me. The D.C. law also requires residents to keep their lawfully owned firearms, such as registered long guns, quote, unloaded and disassembled or bound by a trigger lock or similar device, unless they are located in a place of business or are being used for lawful recreational activities. In other words, if you do own a handgun legally, you have to keep it unloaded. It can't be available for immediate use. It has to be disengaged in some way. That's the law that's at issue here. The defendant, Richard Heller, is a special police officer in the district in Washington, D.C., authorized to carry a handgun while he's on duty at the Federal Judicial Center. He's a security officer, a special police officer who has a permit to carry a gun while he's working. He applied for a registration certificate for a handgun that he wished to keep at home, but the district refused. Thereafter, he filed a lawsuit in the Federal District Court for the District of Columbia on Second Amendment grounds, seeking to enjoin the city from enforcing the bar on the registration of handguns, the licensing requirement insofar as it prohibits the carrying of a firearm in the home without a license, and the trigger lock requirement insofar as it prohibits the use of functional firearms within the home. The district court dismissed the respondent's complaint. The Court of Appeals for the District of Columbia Court found in Heller's favor. Consequently, it's the District of Columbia that filed suit in the Supreme Court. It's not Heller versus the District of Columbia. It's the District of Columbia versus Heller. Because the District of Columbia is going to the Supreme Court in response to the appeals court's finding in favor of Heller. That's the issue. And that's the basis on which Justice Scalia, writes his majority opinion. This is the introduction to the opinion by Justice Scalia. The two sides in this case have set out very different interpretations of the amendment, of the Second Amendment. Petitioners, that would be the district, petitioners and today's dissenting justices, the minority, believe that it protects only the right to possess and carry a firearm in connection with military service. The respondent, Heller, argues that it protects an individual right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally lawful purposes, such as self-defense within the home. So that's the case. That's the position of each side. And in his extensive opinion, Justice Scalia is going to find for Heller. In other words, he is going to conclude that the Second Amendment does not restrict bearing of arms to militia service. Rather, that the right to bear arms affirms every individual citizen's right to own a gun for his own protection in his own home. That's the issue that Justice Scalia sets out. That's the conclusion that the majority of the court will reach. The 27-page opinion is Justice Scalia's reasoning to get there. In other words, it's allowing the decision to drive the use of evidence. It's not the presentation of evidence that leads to the decision. It's the decision that's driving the evidence. That, it seems to me, is a classic definition of judicial activism. We've reached the top of the hour. It's just 1 minute past. We're going to pause and take a 5-minute break. I think we probably all need it. And when we come back, we'll get into Justice Scalia's reasoning. We'll also get into a little bit of Justice John Paul Stevens's dissent. You're listening to the Virtual Center for the Study of the Constitution and Civic Responsibility. We're going to pause for a 5-minute break, and then we'll be right back. Please stay with us.
We now return to the Virtual Center for the Study of the Constitution and Civic Responsibility. Here's your host, Dr. Bill O'Brien.
Thank you, Agnes, and welcome to our second hour here at the Virtual Center on this Monday. It is the 11th day of January in the year 2016, and if you are just joining us, welcome to the program. If you have been with us through the first hour, I thank you for staying with us. That means a lot. If you've been through an hour and you're still there, then I like to believe it's because there's something that's happening here that is worth your while, and I'll do everything I can do to make sure that is true as often as I can. I'd like to do it all the time, but I won't claim to be able to do that successfully. I'd love to hear from you. Our phone number is area code 304-663-4676. That's 304-663-HORN, HORN, 4676. If you'd like to communicate directly with me, I'd love to hear from you in an email. My email address is waobrien906@gmail.com. That's waobrien, OBRIEN 906. That's all one word, lowercase, @gmail.com. And then finally, there is our Facebook page. And if you go to Facebook and type in the Virtual Center for the Study of the Constitution, you will have our Facebook page. And there are a number of postings there that I encourage you to look at, and I welcome your comment on them. You can comment either in with the comment opportunities that are available to you on Facebook, or you can send me an email at waobrien906@gmail.com, or you can give us a call on one of our live programs here on Mondays, Tuesdays, and Wednesdays at the Virtual Center. I just want you to know that this entire initiative, this entire effort is about you, not about me. And so whatever makes your appreciation of this program that much better, I'm interested in doing or following through on. So with that, if you are just joining us, we were in our first hour dealing with the whole issue of the Second Amendment. We were led to do it by some of the research we looked at in last week's programs by Saul Cornell. I shared with our listeners in the first hour an article that I've submitted based principally on Cornell's research. But the fact of the matter is, much of the debate over that issue revolves around Heller. So I believed, and I think I'm correct, that our mission here at the Virtual Center almost demands that we go to the sources themselves. And in this case, it's District of Columbia versus Heller, the majority opinion written by Justice Antonin Scalia for the conservative majority, and the dissenting opinion written by Justice John Paul Stevens, who writes the dissenting opinion for the liberal minority of 4. This was a 5-4 decision. And we've been talking, and we didn't really get into the decision, the rationalization at all. All we basically did at the end of the first hour was talk about the decision itself and the whole issue of the Second Amendment. So we're just about ready to head into the Heller decision at this point. And so if you are just joining us, I think you're right up to date with us. I don't think we're ahead of you at all. The last thing that I did at the top of the hour before we took our break was to read from the introduction to the decision, to the opinion, Justice Scalia's explanation of the two sides in the issue. The minority decision, the dissenting opinion written by Justice Stevens, supports the petitioners in this case, which is the District of Columbia, trying to argue for the constitutionality of its own law banning handguns in Washington, D.C. And Scalia says petitioners and today's dissenting justices believe that the Second Amendment protects only the right to possess and carry a firearm in connection with military service. Heller, the respondent, argues that it protects an individual's right to possess a firearm unconnected with service in the militia and to use that firearm for traditionally lawful purposes, such as hunting, self-defense, and self-defense within the home. Justice Scalia goes on. I'm not going to read the whole decision, but I've highlighted certain elements here, so let me share those with you. Justice Scalia says, the Second Amendment is naturally divided into two parts. The former does not limit the latter grammatically. Now, this is important. It is divided into two parts. And what I would like to do at this time, can you believe I didn't even bring a copy of the Second Amendment with me? But I think here it is, it's quoted. It's quoted by Justice Stevens, so I've got it. The Second Amendment reads as follows, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Let me read it again without the commas, because I think it's easier to understand. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's the amendment. Justice Scalia points out that the amendment is naturally divided into two parts. Its prefatory clause, the first one, a well-regulated militia, and its operative clause, the second one, the right to bear arms. Justice Scalia makes this statement: the former does not limit the latter grammatically, but rather announces a purpose. The amendment could be rephrased Because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Justice Scalia said it could be worded that way. But his suggestion is that what is in the first half doesn't necessarily regulate or control what the second half says. And that's the issue that Justice Scalia focuses on at the outset. And then he does something which I think, more than anything else, reinforces the idea that he is determined to reach a particular decision in this opinion. There are two phrases or two clauses in the amendment. Again, let me read it. The first clause, a well-regulated militia being necessary to the security of a free state. That's the first clause. The second, the right of the people to keep and bear arms shall not be infringed. The first phrase, the well-regulated militia, is what Justice Scalia calls the prefatory, the introduction, in other words. But the operative, his claim is that the operative part of the amendment is the right to bear arms. I would suggest to you that is an assertion. It is not necessarily a fact. He assumes it for purposes of his argument. But the fact of the matter is, what he is basically saying there is that the real heart of the Second Amendment is the right to bear arms part. And that the first part, the well-regulated militia, is only introductory or prefatory to the second, which he calls the operative part. Of the amendment. He calls it the operative clause. I think that is a little bit significant, because what he's doing at the outset is basically making a decision that the real heart of the Second Amendment is the right to bear arms, not the malicious, the well-regulated militia. And then he follows through on that by making the decision that since it's the operative clause that is the key one, I'm going to have to pause for a moment. I had a cat in here with me, and my cat decided that he wanted to get out. And I had the door closed, so that I apologize. What Justice Scalia does is he decides that, in his opinion, he's going to consider the operative clause first. And then he's going to follow it up with the prefatory clause, only to make sure that is consistent with the operative clause. In other words, he's taking the second half of the amendment and considering it first. And he's taking the first half of the amendment and placing it second. It seems to me that one could guess before reading the first line in his opinion that he's taking that license, he's doing that for a reason. It's not just, to use an expression, the old 6 of one, half dozen of the other thing. In other words, I think we would be incorrect if we say it really doesn't matter which end of the amendment he deals with first. Because if it didn't matter, then the two halves would not even be connected. They'd be standalone. So by taking the second half and putting it first, Justice Scalia is dictating, it seems to me, as to where he believes the priority is in this particular amendment, which is in the second part. And then, in proceeding with his opinion, he then begins to deal with the particular words used in that operative clause. And again, the operative clause is the right of the people to keep and bear arms shall not be infringed. I don't intend to go through every line here, but let me talk about the strategy or the structure, the organization of the majority opinion. Justice Scalia begins with the opening clause, phrase of the operative clause. The first words, the right of the people to bear arms, to keep and bear arms, shall not be infringed. So the first issue that he addresses in his opinion is the term or the phrase, the right of the people. And what he does is set out to define people. And this is the way he does it. He says that the first operative or feature, the salient feature, if you will, of the operative clause is that it codifies the right of the people. And then he makes reference to the fact that, ignoring the amendments for a minute, the unamended Constitution and the Bill of Rights uses the phrase, the right of the people, 2 other times. In the First Amendment and in the Fourth Amendment. Then he talks about the Ninth Amendment as using very similar terminology. And then he points out that the interpretation of the First Amendment, the Fourth Amendment, and the Ninth Amendment, all 3 of them, unambiguously refer to individual rights, not collective rights, or rights that may be exercised only through participation in some corporate body. In other words, Justice Scalia insists that right of the people in the Second Amendment be consistent with right of the people in the other amendments. And since the right of the people in the other amendments focuses principally on individuals that make up the people, then he is concluding that the right of the people in the Second Amendment refers to individuals as well. And so therefore, his reasoning suggests that right of the people means the right of the individuals to own guns. It is brilliant logic, but it's logic and it's crafty, skilled argument as well. Early on in the opinion, again, it's 27-page opinion, on page 3, which means that it was still early in the opinion, Justice Scalia writes the following, quote, "The people seems to have been a term of art employed in select parts of the Constitution. Its uses suggest that the people protected by the Fourth Amendment and by the First and Second Amendments, and to whom rights and powers are reserved in the Ninth and 10th Amendments, refers to a class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community." In other words, the first issue, the first point that Justice Scalia wants to and has to make is that when we're talking about the people, we're not talking about the community of the people. We're talking about the individuals who make it up. And the way he reaches that conclusion is to contrast the Second Amendment with others, which indicates that the other amendments deal with individuals who make up the people, all the people, not people who only belong to militias. That's the key he's going to get to. Once he establishes the fact that the people means the individuals who make up the national community, then it's the individuals who have the right to bear arms, whether in fact they belong to a militia or not. And that's the way he's justifying his decision. In one place, at the very end of this section, where he deals with the right of the people, he says, "We start, therefore, with a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans." Remember, he hasn't even mentioned the word militia yet, because he's taken that entire first clause of the Second Amendment and held it for the end. So he's only dealing with the part about the right of the people to keep and bear arms. Now he's defining people as the individuals. And that therefore, since the other amendments, when they mention the people, refer to individuals who make up the people of the nation, then his conclusion or assumption is that the founders must have intended the Second Amendment to be read the same way. That's why in the piece that I wrote, that I read earlier in our first hour, that's why I referred to some of Justice Scalia's writing as tortured logic, because I really do believe that it is. Then he gets in the operative phrase to the issue of keeping arms, the right of the people to keep and bear arms. Now he's talking about keep arms. And remember, he's already determined that the people is every individual, not the community at large. Now he's talking about keep and bear arms, but initially he's only talking about keep arms. He says the phrase keep arms was not prevalent in the written documents of the founding period that we have found. But there are a few examples, all of which favor viewing the right to keep arms as an individual right unconnected with militia service. And he goes to Judge Blackstone, William Blackstone, writing about England in the 16th and 17th centuries. And he says, William Blackstone wrote that Catholics convicted of not attending service in the Church of England suffered certain penalties, one of which was that they were not permitted, quote, to keep arms in their houses. And so because Blackstone in England 2 centuries earlier referred to keeping arms as keeping them in their homes, now he's going to transfer that to the Second Amendment and suggest that that's what keep in the Second Amendment means. Keeping arms means keeping them in your own home. Now he's criticizing the petitioners. He's criticizing the minority opinion. He says petitioners point to militia laws of the founding period that require militia members to keep arms in connection with militia service. And they conclude from this that the phrase keep arms has a militia-related connotation. He says this is rather like saying, since there are many statutes that authorize the Greaves employees to file complaints with federal agencies, the phrase file complaints has an employment-related connotation. Keep arms was simply a common way of referring to possessing arms for militiamen and everyone else, Scalia says. So what he's done now is taken people to mean individuals. Now he's taken the word keep arms to refer to the right of the people, the individuals, all the individuals in the country, to keep weapons within their homes. And he goes to British history to support that interpretation. Once he finishes with keep arms, then he's going to take on the issue of bearing arms. He says the phrase bear arms also had, at the time of the founding, an idiomatic meaning that was significantly different from its natural meaning. To serve as a soldier, to do military service, fight, or to wage war. But he suggests that that's not the exclusive use of the term either. And that's the process. He criticizes Justice Stevens in the dissenting opinion by saying the following. Justice Stevens, excuse me, I didn't have my microphone on, I'm sorry. Justice Stevens points to a study supposedly showing that the phrase bear arms was most frequently used in a military context. Of course, as we've said, Justice Scalia says, the fact that the phrase was commonly used in a particular context does not show that it's limited to that context. And in any event, we've given many sources where the phrase was used in non-military contexts. In other words, what Justice Scalia does, which is part of the reason why his opinion is 27 pages long, what he does is he goes out and tries to find evidence where bear arms was used in a non-military setting. And when he finds them, he includes them. And so therefore, he concludes that the Second Amendment's issue of bearing arms does not relate only to the militia, but, and again, this is his rationale, it pertains to everybody, because he's already established that the right of the people means the right of every individual in the society that comprises the people. And then he's also suggested that keeping arms means keeping them in your homes. Now he's talking about bearing arms, which is frequently used in a military context. And what he's suggesting is, just because it's most often used there doesn't mean that it's exclusively used there. And so then he goes out and finds a number of places where bearing arms is used without any reference to a militia. It's not until we reach page 10 of his opinion that Justice Scalia even deals with the phrase about the well-regulated militia being necessary for the security of the state, of a nation. His opening line then, now he's going to connect the first part of the Second Amendment with the second part, which he's already done first. He says, we reach the question then, does the preface fit with an operative clause that creates an individual right to keep and bear arms? His answer, it fits perfectly. Once one knows the history that the founding generation knew and that we have described above. That history showed that the way tyrants had eliminated a militia consisting of all the able-bodied men was not by banning the militia, but simply by taking away the people's arms, enabling a select militia or standing army to suppress its political opponents. This is what had occurred in England that prompted codification of the right to have arms in the English Bill of Rights. So what he has done is write the history of the use of that language to the point that he has made the right to bear arms an individual right of all the people in the nation. And only after he's done that does he raise the well-regulated militia part of the Second Amendment. And so then his question is, does the prefatory clause, the first part, fit with what we've had? And he said, yeah, it fits perfectly once you understand what they understood, what the founders meant but didn't say. Justice Scalia says the following: the debate with respect to the right to keep and bear arms, as with other guarantees in the Bill of Rights, was not over whether it was desirable, all agreed that it was, but over whether it needed to be codified in the Constitution. During the 1788 ratification debates, the fear that the federal government would disarm the people in order to impose rule through a standing army or select militia was pervasive in anti-federalist rhetoric. And then he quotes John Smiley, the leader and outspoken opponent of the Constitution in Pennsylvania. He says, John Smiley, for example, worried not only that Congress's command of the militia could be used to create a select militia or to have no militia at all, but also as a separate concern that when a select militia is formed, the people in general may be disarmed. So basically, what Justice Scalia has done is turn the Second Amendment around, literally, in order to support the case that he wants to make, which is that the Second Amendment guarantees every citizen the right to keep and bear arms. And that becomes the Heller decision. Justice Scalia makes the following concluding point. It is therefore entirely sensible, he says, that the Second Amendment's prefatory clause announces the purpose for which the right was codified, to prevent elimination of the militia. The prefatory clause does not suggest that preserving the militia was the only reason Americans valued the ancient right. Most undoubtedly thought it even more important for self-defense and hunting. But the threat that the new federal government would destroy the citizens' militia by taking away their arms was the reason that right, unlike some other English rights, was codified in a written constitution. And that's Justice Scalia's explanation of the Second Amendment. It seems to me the issue calls for some serious attention to that. Because that's exactly the position that so many people in this country wanted to hear. One of the things that has concerned me, it's not a legal issue. It kind of indicates that I'm not an attorney. But one of the first things I thought of when I first became acquainted with Heller, why did it take 250 years under the Constitution before this thing was finally resolved? More important than that, why has the Supreme Court not taken on gun cases since? It seems that once they made the law, that was their objective achieved. To me, that's the way I saw it. So then it seemed to me the issue is Justice Stevens's dissent. And I want to share with you, and I know we're running out of time. We'll probably have to deal most of tomorrow's program with Justice Stevens, but I really do believe that this is important. I think it's on everybody's plate. It's on everybody's television. It's on the news everywhere. It's going on in Oregon. It's happening in our cities. People are packing guns, sidearms, in grocery stores and movie theaters and churches and everywhere else. I mean, it seems to me that we got an issue here, and that the issue has not been resolved by Heller. If anything else, it's been called into serious questions. This is what Justice Stevens says in his dissent. The Second Amendment was adopted to protect the right of the people of each of the several states to maintain a well-regulated militia. It was a response to concerns raised during the ratification of the Constitution that the power of Congress to disarm state militias and create a national standing army posed an intolerable threat to the sovereignty of the several states. Neither the text of the amendment nor the arguments advanced by its proponents evidenced the slightest interests in limiting any legislature's authority to regulate private civilian uses of firearms. Specifically, there is no indication that the framers of the Second Amendment intended to enshrine the common law right of self-defense in the Constitution. So obviously, Justice Stevens, in his dissenting opinion, takes issue with Justice Scalia's rationale in Heller. And I find this particularly interesting because of the Miller case. Let me share this with you. Justice Stevens points out, in 1934, Congress enacted the National Firearms Act, the first major federal firearms law. Upholding a conviction under that act, the Supreme Court held, quote, in the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument, unquote. In other words, in 1934, in a question about an issue about the National Firearms Act, the Supreme Court said that in the absence of any evidence that the Second Amendment guarantees the right to keep and bear such a weapon. This was the Miller decision. And now Justice Stevens goes on and says the following. The view of the amendment we took in Miller, that it protects the right to keep and bear arms for certain military purposes, but that it does not curtail the legislature's power to regulate the non-military use and ownership of weapons, is both the most natural reading of the Second Amendment's texts and the interpretation most faithful to the history of its adoption. In other words, in the Heller decision, Justice Scalia overturned the Miller decision. And Justice Stevens is contesting that and arguing that there's no reason to do it because there's no evidence to suggest that the Miller decision was wrong when the court said that there's no evidence that the Second Amendment pertained to anything but malicious circumstances. Let me share with you this paragraph. This is one I wrote while beside in the margins because I think this is pretty important. Justice Stevens says the following. The opinion the court announces today, which is the Scalia opinion in Heller, the opinion the court announces today, Stevens says, fails to identify any new evidence supporting the view that the Second Amendment was intended to limit the power of Congress to regulate civilian uses of weapons. Unable to point to any such evidence, the court stakes its ruling on a strained and unpersuasive reading of the amendment's text. significantly different provisions in the 1689 English Bill of Rights and in various 19th century state constitutions, post-enactment commentary that was available to the court when it decided Miller, and ultimately a feeble attempt to distinguish Miller that places more emphasis on the court's decisional process than on the reasoning of the opinion itself. Unquote. Justice Stevens is saying in that paragraph that the majority in the Heller decision was practicing judicial activism. That the way that Justice Scalia argued for his decision in Heller is much more meaningful, Stevens says, than the decision itself, because it indicates that this decision was one that the court wanted to reach. And again, I think the best example of that is the way Justice Scalia deals with the Second Amendment. He takes each clause separately, separates them. Then he deals with the second clause first, because that's where the decision lies that he wants to make. And then after he finishes his case, makes his case for a particular reading of that second clause, then he reintroduces the first clause and argues that it's very consistent with the second clause as he has explained it. In a sense, then, he has relegated the founders' mention of a well-regulated militia. He has relegated that clause to meaningless status in the Second Amendment. And he has elevated the second clause to become the first one. It seems to me that's some really shrewd maneuvering and manipulation of language. So this is what Justice Stevens sets out to do in order to refute Justice Scalia's argument. He says, in this dissent, I shall first explain why our decision in Miller was faithful to the text of the Second Amendment and the purposes revealed in its drafting history. So the first thing I will do will be to address the fact that the court's decision in Miller was quite consistent with the history of the Second Amendment and the circumstances when it was drafted. The second thing I will do in this dissent, I shall then comment on the post-ratification history of the amendment, which makes abundantly clear that the amendment should not be interpreted as limiting the authority of Congress to regulate the use of or possession of firearms for purely civilian purposes. So now he's taking up the Second Amendment, Justice Stevens is in his dissent. But unlike Justice Scalia, he takes the first half of the Second Amendment and deals with it first. A well-regulated militia being necessary to the security of a free state. And he makes the point, and I know we're running out of time. We've got about 3 minutes left in our program. this is probably, let me just read this about what he says about the preamble, because it's probably a good place to pick up when we have our program tomorrow. Justice Stevens says the following: the preamble, the first clause, the preamble to the Second Amendment makes three important points. It identifies the preservation of the militia as the amendment's purpose. It explains that the militia is necessary to the security of a free state. And it recognizes that the militia must be well regulated. In all three respects, it is comparable to provisions in several state declarations of rights that were adopted roughly contemporaneously with the Declaration of Independence. Those state provisions highlight the importance members of the founding generation attached to the maintenance of state militias. They also underscore the profound fear shared by many in that era of the dangers posed by standing armies. While the need for state militia has not been a matter of significant public interest for almost 2 centuries, that fact should not obscure the contemporary concerns that animated the framers. So Justice Stevens, in his dissent, is going to go back to the founding generation. He's going to look at the way that contemporaries, at the time the Second Amendment was ratified, 91, how the Second Amendment issues, the well-regulated militia and the idea of keeping and bearing arms, how these were treated by the states in their own constitutions prior to the U.S. Constitution. And it's very obvious then that the Second Amendment was drafted by James Madison as chair of the committee to put together a Bill of Rights in the first Congress. All the state recommendations for amendments came to Madison. He knew how the states were handling these issues. And based on that, he drafted the Second Amendment. Stevens is going to point out, and I think this is common sense, that at least it seems sensible to me, given the fact that there were so many proposed amendments available, if Madison wanted the Second Amendment to apply to individual rights to own weapons, irrespective of or separate from the militia issue, he would have said that, because he had plenty of opportunities. He had plenty of suggestions coming from different places. So it seems to stand to reason that if he didn't say that, it's because he didn't mean that. That, in my view, is what makes Justice Scalia's argument particularly tortured. He really goes to great lengths to make his points, because the point he's trying to make doesn't seem consistent with the way people looked at that issue at the time. So anyway, with that, I think it's about time we began to bring this issue to a close for today. It is 58 minutes after the hour, so we reached our time today. We'll be back tomorrow. I remind you that tomorrow is Tuesday, and our program will be beginning 1/2 hour later than today. We'll be beginning at 1:30 p.m. in the East, and we'll begin our program. The bulk of our program will be on Justice Stevens' dissenting opinion in the Heller case. I want to thank you for your time and for tuning in today. Again, I want to thank you for your continued support of the Virtual Center, and also and especially of the Head On Radio Network. And I hope that you'll be able to come back and join us again tomorrow. Please have a wonderful evening. Enjoy it. Be especially good to each other. And take care of yourself. Be safe. This is Bill O'Brien. Thank you so very, very much.